Another lawyer is not always the answer. When a child custody dispute becomes difficult, family court often responds by adding another professional. A custody evaluator, for example, a therapist, family therapy, or a private guardian ad litem, commonly called a PGAL, who is a lawyer appointed to represent the child's interests. Sometimes that may be necessary, but I've never seen it be necessary. And even then, necessity should be demonstrated, not presumed. Courts often say the child needs a voice, the case is high conflict, or the judge needs more information. Those phrases sound responsible, but they do not answer the real question. What specific problem is the appointment meant to solve, and is another lawyer the best solution? The recurring problem with PGALs is that they can do either too little or far too much. The too little problem is influence without reviewable work. The PGAL interviews the child privately. The conversation may not be recorded. It almost never is. I've never seen it. The PGAL may speak with parents, teachers, therapists, relatives, and other witnesses, but those discussions are also not recorded either. The PGAL may review selected documents, yet the parties may never know exactly what was reviewed, what was omitted, or how conflicts were resolved. Then the PGAL reports impressions and makes recommendations. What did the child actually say? We never know. What questions were asked? Again, we don't know. Were they leading? What uncertainty did the child express? Which contrary facts were considered? Too often there is no objective record. The too much problem is different. A PGAL may form an early theory of the case and begin interpreting everything through that, even if it's a false theory. Supporting information is emphasized. Contradictory information is discounted. One parent becomes credible, the other parent becomes manipulative or dangerous. That need not involve bad faith. It can be ordinary confirmation bias operating inside a role with extraordinary influence, and it's something that professionals must be aware of and guard against. A lawyer is trained to advocate, however. Advocacy is valuable, but it's not neutral fact-finding. The role also becomes confused. Is the PGAL investigating facts, advocating the child's wishes, deciding the child's best interest, advising the judge, negotiating settlement, or protecting the child from litigation, or some combination? Those roles are not interchangeable. Courts often justify the appointment by saying the child needs a voice, but a child who can communicate already has a voice. The question is whether the judge will hear it directly from the child or receive a lawyer's summary of it. When the court genuinely needs information from a child, it should first consider a limited recorded judicial interview from the child's lips directly to the judge's ear. That interview can occur in chambers, usually using developmentally appropriate questions, preserving a record for review, and can be controlled by the actual decision maker. The judge can explain that the child is not choosing a parent and is not responsible for the outcome of the case. Judicial interviews carry risks, but so do PGAL interviews. No method is perfect. The goal should be to obtain necessary information with the least distortion, expense, delay, and intrusion. Cost also matters. In private litigation, the parents usually pay the PGAL from the same finite resources needed for housing, school, medical care, counseling, and the child's future. Before appointing a PGAL, the court should identify the specific need, explain why a less intrusive alternative will not work, define the role, require reviewable work product, impose a budget, and set an end date or review date. Another lawyer may occasionally be necessary, but another lawyer is not automatically another layer of protection. When the court needs to hear from a child, the simplest answer may often be the best one. Let the judge hear from the child directly.